Hello everyone, welcome to my new blog. Today we discuss about the employment law. So first of all we discuss about the employment contracts. Employment relationship are based on contracts and amount to an agreement between the parties, employer and employee, with mutual obligations to work and to pay for the work. A contract can be in written also in a standard form or by letter, but none of these are essential so long as there is a mutuality of contractual obligations. An oral agreement between the two parties will still be a valid contract. An employment contract consists of any implied terms, trust and confidence, customs and practice, statutory terms, and written and oral terms commonly known as the express terms, together with those part of any collective agreement whose terms are applicable being incorporated into the individual's employment contract. So, discretionary terms cannot amount the custom and practice. Employer have had a legal obligations to have a dispute resolution procedures which as a minimum must give the right to be informed on the nature of the charges and the opportunity to respond. However, the Employment Bill 9 2008 one in force will replace the current provisions with a less formal procedures. Now, organizational structure, organizational consequences of alternative employment relationship. Alternative employment relationship provide organization with the flexibility of engaging the services of the individuals as needed. Maintenance of core employees provide stability to organizations, whereas perpetual or employee provide organizations with the ability to expand the contract, the size of their labor forces based on production demands also part-time, temporary and short-term contracting allow organizations to expand their labor pools to include individuals who might not be interested in full-time long-term work agreement also. Thus organizations can offer work agreements that are consistent with their overall strategic decisions making. Now, working conditions. Abstract working condition range from the employment relationship to the environment in which workers perform their tasks. These articles addresses how working conditions are shaped by regulations. Most commonly, regulations established labor standards, that is sets minima. Regulations can shape structures for negotiations that affect working conditions. Most narrowly, regulations is understood as emanating from government through laws as well as administrative rules also. Social norms all along with workers relatives relative bargaining power also affect working conditions, and some see labor standard as a cost and or as distorting labor markets. For other, standard reflects social norms and power relations between employers and workers. Now, the regulations, working conditions. Working conditions definitions. Working conditions consists of the following elements. Now I discuss about this. The terms of the employment relationship, they include whether the employment relationship is durable or short term, formal or informal. The terms of employment may be explicit or implicit. Access to employment, these access may be equitable or discriminatory in this latter case. Groups of workers may be excluded from employment or have differential access based on their race, ethnicity, gender, age, or other characteristics. The workplace itself work may be performed in a single site, multiple sites, and or from the worker's home. The wage level, time at work and away from the work. This includes the daily, weekly, and yearly number of work hours as well as their scheduling. It also includes provisions for time away from work due to illness, vacations, or leave, or family or medical reasons, or for training also. The supervisory structures and mechanisms. These structure may or may not include procedures for due process in disciplining, discharge, and layoff. It may entail varied degree of protections from supervisory arbitrariness and health and safety conditions in the workplace. These include occupational health, that is, the way in which the performance of work tasks affect workers' physical health and well being, also, and environmental health, that is, whether the environment in which the work is performed has negative effects on physical health. Now, voice at work, this encompasses access to workers, representations, and the shape of the representations structures also. So, these structures may include representative organizations such as labor, trade, unions, or worker associations, as well as participatory structures such as workplace councils. Social protections, social insurance benefits for the individual and their dependents that have been tied to wage employment and are administered through payroll systems. These include, for example, health insurance and pension plan also. So some of the elements of working conditions listed above have a direct relationship to employment and the performance of work, health and safety conditions at work. Others have been historically tied to employment with a particular employment. In USA and the labor market participation in Western European countries, but do not have to be. For example, health insurance coverage can also be provided as a universal benefit regardless for work activity also. Now, impact competitions in the labor market. So, if there are clearly reins in the typical employment relationship, why is an imperfect competition's perspective not pervasive in labor economy? So, there are two sorts of answers. First, that is, has little value added above the perfectly competitive model. It adds more complications than insight. This might be because perfect competitions is seen as a tolerable approximations to reality, so that the mistakes one mistakes by assuming the labor market is perfectly competitive are small. Or it might be because the comparative statics of model of impact and many questions, for example, shifts in the demand curve and the supply curve of labor will be predicted to have the same effects in perfect and imperfect competitions. Now, second reason why many labor economists do not adopt the perspective that the labor market is imperfectly competitive in their work is that they do not adopt any conceptual framework at all. A well designed and executed randomized experiment tells about the effect of an interventions without the need of any theory of or conceptual framework at all. A generations of labor economists have grown up whom are not accustomed to thinking in terms of economic models at all, seeking instead good research design. But while estimates from randomized experiments have internal validity, so their external validity is more problematic. So the results tell us that what happened, but not why, and without at least some understanding of why, it is difficult to draw conclusions from such studies that are the general use of enable us to make a forecast of will happened with a similar not but not identical treatment in another time and place. We want to use evidence not just to understand the past but to improve the future also. So, in practice, people do assume estimates have external validity all the time. They implicitly generalize, but perhaps it would be better if this was more explicit and we had a theory of why, and it is where an overall perspective on the working of the labor market might help. The section that follows 6 do just that. So contracts in employment. A basic features of employment employers interactions is the nature of the exchange in the employment relationship. A employment relationship is contract based on a mutual agreed on and voluntarily made exchange of promises between two or more parties where each party gains if the exchange agreement is fulfilled and each party loses if it's not. Each component can vary in response to the social context in which employment is embedded. Now, a meeting of the minds of employer and employee is implied in the term mutuality, whether there is actually a moment when practice share a crystal clear understanding regarding the terms of their exchange is open to questions. Nevertheless, at the start of the employment relationship, there is at least a perception of agreement, if not necessarily agreement in fact. Both employer and employee have free choice to entering into and accepting the terms of an employment agreement. However, this is always a matter of degree. Voluntariness in employment is historically rooted in the evaluations of institutions such as individuals' rights and ownerships of private property and collective bargaining also. And voluntariness in employment is possible when individuals have the right to control their own time, service or services and use of their skills. Employer benefits regarding workers' freedom of choice, opportunities elsewhere, and influence the inducement that employers offer in exchange for workers' contributions. Now we discuss about the employment regulations comprises the legal rules and institutions that constitute, govern, and structure the employment relationship. Employment regulations comprises both alternatives or affirmative and interventions also into the employment relationship through status, administrative regulations, and executive orders also, as well as background rules that govern contracting between private parties. In most Western nations, there are two types of labor relations status. Those that impose direct regulations and on the terms of the wages bargain, and those that are legally empower labor and management to engage in collective of self regulations. Direct employment regulations includes status that set minimum wages and maximum hour of work and mandate certain health and safety standard, regulate employer based pensions and health insurance also, and provide anti discriminations protections. And collective labor regulations include status that enable employees to form unions and bargain with employers for the terms and conditions of employment. And countries differ as to both the terms of form of content of their labor regulations. So this article focuses on the development of employment regulations in the United States. It traces the evolutions of both collective and individual employment regulations, while the specific way in which the US labor laws developed is unique. The history of US employment labor regulations illustrates the issues that are addressed by all employment regulations regimes. So that's the end of my video, my friends. If you like my video, please subscribe my channel. Thanks a lot for watching.